Oregon's landmark child abduction law, ORS 30.868, has its roots in the abduction of Sean Cruz's 4 children. The 4 Cruz children vanished from their Oregon homes on February 12, 1996, during the historic Great Storm of that year. The children vanished into Utah in a Mormon abduction shunning carried out by Mormon leaders in Oregon, Washington, and Utah. Several LDS bishops, the Hillsborough Relief Society president, the Vancouver LDS stake president, Edwin Poyfair, and his counselor, Corey Wright, violated Oregon's custodial interference law but were never charged with a crime. Oregon's landmark kidnapping bill, Senate Bill 1041, came to the House floor in the closing days of the 2005 session after having passed the Senate.
Read the bill.
Senate Bill 1041, relating custodial interference and declaring an emergency.
Question now rises upon third reading and final passage of Senate Bill 1041A. Representative Flores.
Thank you, Mr. Speaker. Colleagues, 1041 comes to you as the result of a lot of work by Senator Avell Gordley and her legislative aide, Sean Cruz. I'd like to give you a little background and share some of the reasons that this bill came forward and why it is a very, very important vote for all of us. Senate Bill 1041A is a consensus bill reached by a work group and several members of the Senate President's Interim Task Force on Parental and Family Abductions. The task force heard compelling testimony from victims of child abduction and came to understand that this class of victims were falling through the cracks at many points in the enforcement of existing law in Oregon and across the nation. They came to hear a lot of information that this crime has immediate, severe, and potentially unrecoverable consequences for the victims, and that a statewide campaign to educate judges, the bar, the general public to the scope of the problem is necessary. Under the auspices of the Oregon Commission on Children and Families and the Oregon Judicial Department, that education and strategic planning effort has begun. The State Bar is coordinating the fast-track education of practicing attorneys and child abuse and mental health licensing boards and are working similarly in their respective fields. The provisions of the bill come at the request of victims of child abduction. There is no known opposition to this bill, and there is no fiscal impact. Senate Bill 1041A creates a civil action for the crime of child abduction in the first degree if the child has been removed from the state. Accordingly, the statute of limitations does not run at any time while the child victim is removed from the state. Victims stated that the first priority following an abduction is that the child is returned safely and immediately. Most often, law enforcement was slow to act or took no investigative action because a family member of a victim was involved in the abduction. Victims encounter attitudes based on incorrect assumptions, most often that if a child is with a parent, no real emergency exists. The task force concluded, however, that the abduction of a child does call for emergency action. Victims recognize that many child abductions involve third parties who are criminally culpable and who may have knowledge of where the missing child is located. Since the location of the abducted child, victim, and the abductor are not known, victims believe that filing a civil action with potential financial sanctions against a culpable third party may serve as a lever to accelerate the recovery of the abducted child. This bill, upon a finding of good cause, the court may assess the costs of providing counseling, medical, and other relief to the victim. Senate Bill 1041A includes an affirmative defense for persons, including third parties, if the child has been taken, enticed, or kept in violation of the Oregon Revised Statute, custodial interference statutes. But the reason for the violation was to protect the health and safety of the child victim or of the person who has been taken, enticed, or kept the child. Children are most likely abducted by persons known to them or related to them. The Task Force on Parental and Family Abductions found that abductions under these circumstances are a form of child abuse, as devastating to the victim as any other form of abuse. The task force had developed recommendations for legislation, and this is the result. Victims wanted an alternative remedy to criminal prosecution of a family member. The civil cause of action provides that alternative. Victims recognized through bitter experience that lack of awareness in the courts by law enforcement and by the general public, including the victims themselves at the time of the crime, was making these cases exceedingly difficult to resolve. A child abducted by one parent from another, a child torn in half, a child who has abruptly disappeared, a grief-stricken parent frantic with worry. These are examples of breakup beyond divorce. An abduction is intended to be permanent, and many of the consequences are permanent. The victims are scarred forever, yet the lack of civil liability remedies imposes all of the costs of attempting to locate a missing child, all of the costs of recovery, all of the medical and all the other burdens on the victims instead of on the parties who perpetuated the crime. The best possible scenario is that the abduction does not occur in the first place. At the time of a civil cause of action is filed, an adult victim may not know the whereabouts of the abducted child victim or of the child's abductor. Filing the action against a third-party co-participant in the abduction whose whereabouts is known provides a lever that may result in the return of the child victim. The threat of this action is intended to serve as a deterrent to third-party participation and to the incidence of child abductions. Colleagues, many of you know, not that I'm a fifth-generation farmer, as a good representative from Sublimity, but I am a grandmother of 9 children. And 2 of my grandchildren have been abducted from my son. Their whereabouts are somewhere deep in Mexico. This bill will not help our family, but I urge your support to help other families. Thank you.
Discussion. Representative Worth.
Thank you, Mr. Speaker. To the question of carrier.
Question of the carrier. Does the carrier yield?
I do.
Your question, please.
Thank you, good representative. I'm concerned, voicing concerns of many people that I've spoken with, and as you know, I've got personal experience with this as well, and I want to make sure that the bill is actually not having unintended consequences, because there are many that believe that a bill such as this that creates a crime for the custodial interference in any degree is a stepping stone to a bigger picture, a larger goal of basically criminalizing the action of interference with parenting time in any degree, and which would be could possibly be one parent not allowing parenting time to the other parent and making therefore it a criminal act. Can you please let me know that that's not what we're doing here? We're not on a ladder up to a much bigger goal of that.
Thank you, Representative. This is a civil cause of action, not a criminal penalty.
Follow up, Mr.
Additional question. Did carrier yield?
I do.
Your question.
I do realize that, and what I want to say is there's a lot of literature and case studies out there that say that this is that it's part of a bigger goal, and that first we will get the civil action brought, be able to bring it against these abductions, and then, like the next session, we'll come back and work for criminalization of parental time interference, or if are basically making the civil penalties for parental time interference extremely, extremely harsh, much harsher than they are now. I just want to make sure that this isn't a stepping stone of a bigger picture, a bigger goal, a bigger plan.
Representative, what I can assure you from the testimony that we heard from the Senator and her leadership in the task force is that this is to address a very serious overlooked problem that is ongoing, and there is no effort to encroach on parental time, but certainly the abduction by one parent of children. This is not an effort to use as a stepping stone.
Further discussion? Seeing none, Representative Flores, do you wish to close? Those of the opinion the bill should pass will vote aye. Those opposed, no. The clerk will open the voting system. Representative Flores, how do you vote? She votes aye. Senate Bill 1041A, having received the constitutional majority, is declared passed.
Senate Bill 1041 is now ORS 30.868, making Oregon the first state in the nation where kidnappers can be held accountable by their victims in civil court. Aaron Cruz died of undetermined causes in Payson, Utah, as a result of the Mormon kidnapping. The LDS abduction shunning of the Cruz family continues. Kidnappings are continuing crimes and do not end because a child victim has become an adult or because law enforcement has failed to act. They end when the child is recovered.